Hi guys, welcome back to the chapter 5 now. We are talking about the business law. This is in particular for the use of the elements of contract in key form of commerce and technology. This is 21st century. This is what's going on now. There's a lot of online business, so you need to understand this particular subject. So there are a number of things that I just need to mention. This is owned by McGraw-Hill again in terms of copyright. It is this slide is owned by prepared by John Piccolo of Niagara College. Okay. All right. There's about five objective. There is about nine objective for this chapter. Number one is know what the contract is. Number two, what separate the contract of an agreement. Number three, why contract are useful and needed. Number four, recognize the difference between invitation and trade and offers. Number five, understand the elements of the contract. Number six, know how valid consideration in intention affect a contract. Number seven, recognize what option agreement are. Number eight, understand the express and implied terms of a contract. Number nine, contract the oral, written, electronic form of a contract. Let's dive in right away. What is a contract? Contract is an agreement. They are enforceable through the law, agreed upon by law or more parties with benefits for all parties to the contract. It does not have to always be a formal or written agreement. While contract can be in writing, only few have to be in writing because of the law. Okay? But most of the contract that I know, it is in writing. Why? It is because if there's any dispute or any disagreement, it can be easily enforceable. It's not based on you say, they say kind of things. Okay? It has to be written, the better it is. Contract law 1, okay, we continue on. Contract law is a set of legal principles and rules that allow enforceable agreement to be created. It depends the right and obligation a party has and whether they negotiate them directly or not. Primarily about the process that creates a framework within which contract is created. The substantial aspect of contract, what the contract is actually going to do within the control of a party, include the subject matter of the contract, its delivery, the terms of payment, terms such as warranty, length of the contract. For example, a room rental agreement. For example, I'm the landlord. I'm looking for tenants. I create a specific tenant lease agreement for 6 months. That's a good example of a contract. Okay, it has some strict time. For say from January to June, let's say, the rent will be about 1,000, let's say, including utilities, it's fully furnished. So that's the kind of standard of the contract. A contract is an agreement that the party intend to be enforceable by legal system. It's often called a meeting of minds. It's an agreement in exchange of promises. When this mind is set, an agreement is formed. Okay. Contract versus simple agreement. The difference between simple agreement and contract is that a party can use the courts to enforce all contracts. So when it's first, it is signed, it can use the court to resolve the disagreement. Simple agreement are not enforceable. This is the key part. Okay, contract can use court, but simple agreement cannot enforceable. That's why, let's say if I'm leasing a room, I put a contract. If it is simple agreement with no say, it's not enforceable. Okay, express term are those terms and negotiated specifically by the parties. Contract versus simple agreement. Okay, this is continuation of the previous slide. Implied terms are those terms imported into the contract from other sources. Laws or regulation that applies to the contract, past behavior by the parties in the previous contract, and industry-wide practices in the area of the contract. Why are the contracts needed? It is the basis of a commercial liability. Okay, it provides basic protection of a personal right in a commercial deal. Okay, for example, if I'm leasing to a tenant for 6 months and the tenant do not pay, then I have a remedy to cover the non-payment. Courts do not interfere with contract except in cases where there are clear problems that the party cannot resolve. Okay, that's the key part. So the court will step in if there is any dispute and cannot be resolved. What is UECA? It is called Uniform Electronic Commerce Act. UECA. The purpose is To recognize that electronic contract were as valid as any other forms of contract to which the basic rules of contract applies. To clarify, those rules apply in unique situations caused by electronic contract information. Okay? In every contract goes through the process of agreement before it is formed. There has to be a valid offer from one party and valid acceptance from the other. That's the key part. One has to offer, the other to provide an acceptance. These are the key rules that make the offer and acceptance valid. Okay? Offerer is the person making an offer. That's the person who make an offer is called offerer. Offeree is the person to whom the offer is made. Party can switch roles during a negotiation. Excuse me. Invitation to trade. Anything that shows a willingness to conduct a business transaction. That is called invitation to trade. The formation of contracts starts with the invitation to trade, includes most advertisements. Okay. To form a contract, this is the contract requirement: offer, acceptance, consideration, and intention. There has to be 4 requirements. To form a contract, one needs to satisfy the following 4 requirements. Number 1, it has to have an offer. Number 2, it has to have an acceptance. Number 3 is consideration. And lastly, intentions. Okay? What is an offer? An offer is promise to enter a contract under complete and specific term. One, there is a communicated acceptance. It must specify the parties, the product, and the price. If any of the 3 are missing, invalid, then the offer has not been made. Okay? What is an acceptance? One of the parties must accept the offer made by the other party. Any alteration of the offer is a counteroffer and simply continues to as a bargaining process. Usually requires the accepting party to perform a positive act or signaling of the acceptance. Okay? Acceptance, continuation of this previous slide. Not doing anything or silence will be acceptance only if the party have previously agreed that this is a reasonable method for acceptance. There are other ways to accept an offer so long as both parties have agreed upon this. In terms of forming a contract in figure 5.1, there's an invitation to trade, there's an offer, there's an acceptance, then there's a contract. Okay? That's 4 steps there. That's the forming of the contract. In consideration that each party must give and receive something of value. Most often, one party provides goods and services to the other, who provides money to the first party. And then it can take the form and exchange goods or services. Intentions. Both parties must have the intention that the agreement will be enforceable through the court system if necessary. If the 2 parties do not get along, they can resolve the problem, do not meet the agreement before, then it can go to the court system to enforce it. If the parties go to trouble to negotiate and reach an agreement, the law assumes that the intention was present. Beyond the basic completeness, revocation, communication, promises, and special situation. Ways an offer can end. There's a set time limit to the offer set up in the offer. There is a natural time limit to the offer. The offerer revokes the offer as long as it is done before a valid acceptance is made and is communicated clearly to the other party. Offer. What is an offer? Ways an offer that can end: the person making an offer dies, goes bankrupt, or suffers a severe mental breakdown. The other party can simply say no to the other offer. The other party makes counter offer, which really is a rejection of the original offer. Acceptance both ends often creates to the contract. Acceptance. Acceptance must be communicated to the offerer, either face-to-face, via email, through fax, through phone, or other electronic means to service in the mail system. Okay? Acceptance. Okay? Post continuation of the previous slide. Post box rule is an offer is accepted when the acceptance is given to the postal service, not when it is received by the offerer. Exception to the rule that communication must be received for an agreement to be formed. Responding counter offer is an offer, there must be a counter offer, revocation, refusal, and then there's no contract. That's it. In terms of consideration, the obligation is party owes to the other under a contract. It is an enforceable contract requires something of value to be exchanged between the offerer and the offeree. Okay. Key elements in terms of considerations. What are them? It is considered that doesn't have to be an equal value as long as each party receives some sort of the benefits. The benefits must be tangible or intangible, then recognizable as benefits. Can occur simultaneously for future promises. Final consideration need to be established as long as the method for determining the function has been established. And then key elements in terms of consideration, there's a gratuitous promise or a favor or it is not consideration. What are they doing or agreeing to do? Something for another person with no expectation of getting anything in return. The key elements in consideration are the condition at the market value for similar service, refer to the quantum merit. What is the quantum merit in terms of Latin? It is the meaning what one has earned. It's how the contract loan determined the reasonable price has been paid for a service. Okay. The intention. What are the intention? Intention determine whether or not the parties meant for the agreement to be enforceable by law as a contract. Commercial relationships are enforceable by the courts under contract law. If the relationship is domestic, then agreement is presumed not to be in contract or is not enforceable. What are the option agreements? The option agreements are a contract between potential buyer and seller to some item whereby in exchange for a fee the seller gives a personal right to first chance to buy the item up to a certain date. Okay, this is many times happen. This is what has been done with the new app called Timu. They have a time machine there. Time if you buy in less than 10 minutes, there's a 50% discount. This is a strategy on agreement, okay, to entice the buyer to purchase more. It's an enforceable contract that prevents offeree from withdrawing an offer period to that specified. So a specific time given, okay. The same thing when you buy and sell right issue in a stock market. Terms of contract. Express term is a written contract, the term that actually appear in the documents. It may be subject to interpretation, they are unclear, or because the parties disagree on the meaning of the words. The implied terms mean item occasionally added to the contracts by judges in situation where the contract reaches the courts, gives meaning to the words, or to more clearly reflect that what the judge believed was the intention of the parties at the time the contract was entered into. Okay. In terms of oral, written, or electronic contracts, written contracts are preferred for reason of clarity and certainty. That is the key part. For reason of clarity and certainty for written contract. Oral contract, although illegal in most cases, open the door to disagreement. This can be extremely difficult to prove. Okay, this is the key part I mentioned to you in the previous slide. He says, she says, I say, they say, you say, we say, that kind of thing is difficult to prove. So it has to be put in writing. Everything is better off in writing for the contracts. Okay, there are requirements for written contracts. The 4 types of contract that must be written are: number 1, contract relating to land, including sales and leases of land. Number 2, contract where promises made are not required to be performed within a year of the execution of the contract. Number 3, contracts of guarantee where parties agree to be reasonable for debt or obligation of another. Number 4, in some provinces, contract for the sale of goods above a small stipulated money amounts. Written contracts can also be satisfied electronically. The danger of partial written contract. It is important the written contract to be complete. The payroll evidence rule states that oral evidence is not allowed in the court to expand the written contract. USCA recognizes the contract as valid form of contract to the use of functional equation rules. Legal recognition of electronic information on documents. Legal requirement that information of document to be in writing. Standard form of contract are contract drafted by one party without any negotiation with the other party. Example, rental car contracts, written in a way that greatly benefits the company. Okay, let's look at the key question that you need to know in this particular chapter for each particular objective. Okay, It is stated there in each category in red. Name of the 4 ways an offer can be terminated. Explain the difference between an offer and invitation to treat. Explain the basic requirements needed to create a contract. This is objective number 5. How does the intention determine the enforcement of an agreement? Okay, so each of these quite key questions related to each of the objectives of this chapter when you review it again for the puzzle questions. And then explain the term counter offer, which is objective number 6. Explain the concept of considerations. Okay, what is gratuitous promise? And then explain the difference between express and implied terms in contract. Okay, and what is the function of acquisition cost in the contract? So each has its objective. Let's look at the key term. Contract. Let's review that. Agreement that are agreed upon by two or more parties with benefits for all parties to the contract. Offeror is the person making an offer. Offeree is the person to whom the offer is made. Okay, that's the term 1. Term number 2, invitation to trade. Anything that shows willingness to conduct a business transactions. Offer is a promise to enter into a contract, and counteroffer is a new offer that also rejects the previous original offer. Consideration. The obligation is party owes to the either under the contract. Express term is a written contract, the term that actually appeared in the document. Implied term, item as question is added to the contract by the judges. So that basically concludes this particular chapters. I will upload them in YouTube, and I will prepare as well the Edpuzzle questionnaire so you can review this particular chapter and practices for your business law class. Thank you. Bye-bye.